recording audio now.
Let me make sure I can click. Let me make sure I can click. Figure it out. All right. So, I get in a fight a couple times a week. Seriously, I do. You can ask him. I've done Muay Thai kickboxing for a couple years now, and we openly spar a number of times a week. So the first time you're out there sparring, you're scared to death. You have your hands up. You're protecting your moneymaker, as one of my instructors likes to call it. And you're there, and you're like, "Oh, please don't hit me! Please don't hit me! Come on, I don't like this. This is crazy." You get better, and you start seeing the openings, and someone will drop their guard, and you get in, you punch them, and you start using offense. And then you're thinking, "Wow, what can I exploit? What are my strengths? What are my weaknesses? How can I win? How can I get ahead? What can I use to make a difference?" And that's when it really gets fun. And the reason I use that analogy is because the same thing happens in my line of work. I'm a patent lawyer. I've done it for longer than I've been fighting. And the best thing about what you use the same strategy. You want to work on your defense, make sure no one gets in, takes your products away. You want to work on your offense, protect it, and you also want to exploit it. You also want to make sure that you can get value from what you spend all this money on. Hence, my title, Protect, Enforce, Exploit. So I'm going to walk you through some of the basic types of intellectual property, what they can do, what they can't do, how you use them. I want it to be open and interactive. I promise I will not punch you. But it's that kind of mindset that I bring to my practice about how do we get in, what kind of advantage can we have, how do we have the best defense, and what can we do to make money, to get the most benefit. So hopefully my clicker will work. Yay! All right, so there are 4 basic types of intellectual property, and I'm going to go over them. I want this to be interactive, so ask questions, raise your hand, don't raise your hand, speak up, interrupt me. So there are patents, trademarks, copyrights, and trade secrets. Those are the 4 basic ones, and I'll touch a little bit on licensing, where you license the rights back and forth. But that pretty much covers the world of intellectual property. So let's start with, what is a patent? I know that a number of you have them, or some of you have them, and you have an idea. But what is a patent? A patent's basically the nice little document the US government or some government hands you saying, this is yours, this is your document, this is what you invented, here you go. It's a personal property right. You can buy it, you can license it, you can sell it, you can sign it, you can use it as collateral. Lots of people use intellectual property as collateral for security interests, for bank loans, for getting financing for the, yes?
How is it valued?
You have valuation experts to look at it and say what's out there, how they're doing it, but it is collateral. Yeah. Trademarks are collateral, patents are collateral, copyrights are collateral. Lots of people use them for security interests when they're buying and selling. When they need money for R&D, they use it as collateral because they know it has value because it's backed by the government. So you can do all that with it. It's also territorial, which means you have a patent in the US, it's only good in the US. If you want to have it someplace else, you have to go to that country and follow the rules for getting it. But it is a property right. Bought, sold, licensed. You can divide it up any way you want. And it is worthwhile. There is value to it. So let's talk a little bit about what it is. US patent laws, as well as the copyright laws, which we'll deal with later, are in the Constitution. They thought it was important enough at that time to make it a federal right. So I highlight the important parts for patents. It says Congress shall have the power to promote the progress of science for limited times to inventors for the exclusive right to use their discoveries. It's a limited right of time granted by the Congress. That sets the stage for the United States Patent and Trademark Office. I like to refer to it as Mecca because that's where all my work is. It's in DC. It's remote now too. It's where they issue all the patents and trademark, or they issue all the patents. Every patent you file goes somehow to there electronically, physically, and they go to there. It goes into this nice little mailroom, which is kind of like watching sausage being made. You don't really want to see it. It gets assigned to various examiners who examine it, and we'll go through a little bit through the process. And at the end of the day, you hope you get a patent. But it all happens there. They probably have, 2,000 or more examiners assigned by different art units, they're chemical, there's mechanical, there's electrical, and they all examine their own areas. English is often the 3rd language for them. You know, a lot of them come from foreign to go to law school here, to go to the LLM programs, and so English is their first language. It's maybe their second, third, or fourth.
Can you submit a patent request in a different language?
No.
Oh, you can't.
No, you can't in the U.S., but in other countries it does require that.
Okay.
But so a lot of them are working as English as a third language, trying to understand this technical stuff, and you're trying to communicate. So it's a little dicey sometimes. So patentability. First of all, the Congress says you can promote. So what can be patented? It has to be new, useful, and it has to be patentable subject matter. New, useful, non-obvious, and patentable subject matter. That's kind of a lot of gobbledygook. You know, it's lawyer language. So what does that mean? What is patentable? A process of making a chemical, a machine, which is any article like an engine, something like that. A manufacturer, the classic one you see are ashtrays, lamps, something are made by a process. A manufacturer, articles, things like that. It has to be, and compositions of matter, chemical compounds, mixtures of ingredients, new drugs. Recipes usually aren't patentable. They're very hard to get patentable. You might get trademark or trade secret protection on it if you keep it secret, or you may get copyright protection on some of the things, but it has to be one of these categories, 4 categories: process, machine, manufacture, composition of matter. And that's pretty much the first statute that says it has to be patentable subject matter, or they're not going to patent it. On the contrary, there are certain things that aren't patentable. Laws of nature, physical phenomena, abstract ideas, algorithms, a method for encrypting and decrypting code. Not necessarily patentable unless you put the steps around it, the computer steps and the logical function that comes out of it. It can't be something that they say a human could do, just a human could do it. It may be longer and it may take longer, but if they feel that a human can do it, it's not going to be patentable.
That's a good question. What you just said about putting steps around it, does that mean you could do a process patent to software? Does that make sense?
Yes, you can do a process patent. You can also do software, but what you have to do is have steps that a human can't do. Like, there was one I worked on where they had something. It was an employment application, and they analyzed potential candidates, and they looked at at least 20 different facial expressions, and they categorized them quickly, because your eyes do that, but you don't know you do it. And so they analyze the expressions very, very quickly to put something together. And they said, okay, a human can't do that. They can probably analyze 1 or 2, but you can't instantly take 20 and get a feel for the person and how employable they are.
Oh, wow. Yeah.
So it has to be something like, it can't just be taking data, putting it in a spreadsheet, and sending it out. It has to have something that a human can't do. It has to be tied to some process. You have to do something with it. Like, if you have a computer program that detects heartbeats, you have to do something that says, okay, you're going to detect your heartbeat, and you're going to do some process to it, and then treat them a different way. But it can't just be a computer program.
Oh, that's what I mean, just take advantage of the small crowd.
Yeah.
So do you have to prove a certain amount of repeatability and reliability? I know it has to work, it has to be functional, but what level of functional, how repeatable? I come from devices where that's...
Right. Well, it's not the FDA, so it doesn't even have to be repeatable necessarily.
Oh.
It has to be useful. It can't be a perpetual motion machine. It doesn't even necessarily have to exist.
Okay.
In order to get a patent, you have to conceive the idea, and you have to reduce it to practice. Reduce to practice can be 1, you can actually make a prototype, or 2, it can be constructive reduction to practice, where you actually write it down in a way that someone of ordinary skill could do it.
Okay.
Which a lot of our clients do, because they don't have money to do it all, to make these crazy things, so they put it in a way that someone of ordinary skills. So if you're working on a cancer drug and you think it works and you write it, a fellow person working in cancer drugs would have to understand it, not your average person off the street.
Cool. Yeah, that makes sense.
And so the other thing is, physical phenomena, F equals MA, which, sorry, the geek in me was like, you can't get patents on that. You can get the application of it, how to determine it, what you do with it, but you can't get patents on Newton's laws. Sorry. So the conditions of patentability, there are basically 3, and we'll touch on them quickly. The first is utility. It has to have a useful purpose. It has to do something that works. It's really only a problem for new genes and new drugs. The old joke is, if you have a new chemical composition and you throw it on grass and it kills it, it's a pesticide. If it makes it grow, it's fertilizer. So you have to kind of like think about what the purpose is. It has to have a useful purpose. It can't be a perpetual motion machine. It can't be something that would never work. It can't be reversing the laws of gravity or reversing, I actually used one about reversing aging, which apparently that's not patentable. And it has to be useful. It has to be something that you would use. You know, it can't necessarily be a rocket to the moon if you're never going to go to the moon. The other thing is it has to be novel.
So in terms of useful, if it's useful for one thing, but you discover it could also be useful for something else, does that open up?
It does. You have to draft it really carefully, but it could be, you could have a new use for it. I mean, if you think about things that are patentable, Thomas Jefferson said in the 1800s that everything that was patented has been patented. Well, clearly that's not true. But everything is pretty much old. There's new things, but you put new combinations together and you have new uses for them. So you can find ways that something that you didn't know how to use before, if you tweak it, or you didn't think it would work, and it does because you tweak certain things so it will work. It can be patentable.
Would you?
But I thought that's much more difficult now. Because,
What?
Well, applying a new use for an existing technology or.
Oh, because everything's built, because our technology is so stacked on top of each other now.
Because I've been arguing in the past things like that.
Would you write a whole new patent, or would you try to add on or modify the one that exists? That's where I'm a little confused too.
Yeah, we'll go through the whole process, but you actually have to be the inventor of it.
Oh,
So you can't just,
awesome. Okay.
what you would do is, so if you invented something, and suppose he had something that had components A, B, and C, and you have something that you add D, and it's really much better that way. I use my classic example. You have a 3-wheel vehicle. You have a vehicle having at least 3 wheels. You're like, 4 wheels are so much better. In the patent office, they would say, yeah, 4 wheels are better, it's patentable. So you would have that invention for the 4-wheel vehicle, and he would have the invention for the patent on the 3-wheel vehicle. So while you're adding to what he did, it would be a completely separate patent.
Oh, interesting. Yeah, because the thing that you're looking at is the amount of wheels, not like. Oh, that's interesting. Yeah. So it's the way you write it. Yeah.
And so you would invent the 4 wheels. He would still have his patent on 3. You would have your patent on 4.
Oh, interesting.
Now.
And then you reference. Do you reference them? You reference them as examples, right, or something?
You do. So what you would do is, but suppose you lived in a cave and you didn't know that there were 3-wheel vehicles. If you didn't know it, you don't have to tell the patent office. But if you knew there were 3-wheel vehicles and you had 3-wheel vehicles that you were testing and you had documents of 3-wheel vehicles and you knew everything about 3-wheel vehicles, then you have a duty to disclose that to the patent office, otherwise your patent's invalid. But if you were somehow living in a cave and you never saw a 4-wheel vehicle, a 3-wheel vehicle, you would not have to disclose it.
Okay.
To go off, I'm just going to go off point a little bit here, that when you file a patent application, you do have to disclose everything, everything that you know, that you reasonably know. So we have some clients that will do a patentability search to see what's out there. So everything they find, if it's relevant, they have to disclose it, which is good and bad, because you're kind of doing the examiner's job for them.
Yeah.
We have other clients that don't want to do it. They don't have the money. They don't care. They want to get a patent for various reasons, so they don't disclose it,
Oh.
so they don't have to.
So I think that would delay it because they would just reject it and say all these things exist, but there's a chance they would not find the same things or think the same things.
Right.
Exist, right? Yeah. Okay. Oh, I see. Interesting.
Because you have to understand, when you're getting a patent, you're getting a sanctioned monopoly. The U.S. government does not like monopolies. You're getting a sanctioned monopoly with lots of qualifiers. You get it for a limited time.
Yeah.
You have to disclose everything you know, and you have to disclose the best mode of doing it, which means you have to tell someone how to do it. You can't go, here's the 3rd best way of doing it, and I'm going to keep the best way in my pocket.
Yeah.
That's going to make your patent invalid too. So it's a sanctioned monopoly provided you play within the rules.
Interesting.
So sometimes it's better if you disclose it, because then you're doing the exact job for the examiner, and if you know about it, you already know how to design around it. The problem comes when clients don't do searches, and they think, this is awesome, I'm going to get a patent, and then the patent examiner comes back and says, we found these 5 references, and they're exactly the same, and now you didn't plan for it. Where if you know it, you can plan a little bit for how you're going to make it work. Excuse me 1 second. So, good questions though. So the next thing is it has to be novel. I mean, it has to be new. Has not been done before. That's a pretty easy one. Useful and novel are pretty easy. Like 3 wheels versus 4 wheels, that's novel. Those are the easy ones. The next one is non-obvious. That's kind of a big word that means it can't just be a simple change. So suppose you have a three-wheel vehicle and you have a three-wheel vehicle, but you paint it pink. Not really patentable because the three-wheel vehicle that's pink and a three-wheel vehicle that's blue are going to be the same. It has to be something that someone would think to make an obvious modification to it. So those are the three big ones. First, it has to be patentable subject matter. It has to be useful. It has to be novel. No one has done it before. And it has to be non-obvious. Yes?
So an example for non-obvious might be on my three-wheel vehicle, I patented it I claimed it for moving cargo.
Mm-hmm.
And taking it down the road, and he says, oh, well, no, I'm going to put people on it.
Mm-hmm.
Oh, so that's the difference.
So
You may have to change it in order to make it safe for people, so that may be patentable.
But he could patent a seat to attach to my three-wheel vehicle to carry people. But just saying you're going to carry people instead of cargo is obvious.
Oh,
Yeah, it could be.
Right, yeah.
And the other thing I want to point out that I didn't talk about, novel, is the U.S., by novel it also means it can't be known or used by someone else. So, and that's key, because you can destroy your own novelty. So how that happens is you are so excited about your three-wheel vehicle, you're like, this is awesome, I'm gonna have a three-wheel vehicle, and you start showing pictures and talking about it and saying, when I get this done, I'm gonna offer it to you for sale. You do that today. You start talking about it, showing it around, giving talks. Like probably at Amgen, they gave a lot of talks about new things that were coming out.
It's regulated, but yeah.
It's very regulated,
Yeah.
and the reason why is, if you talk today about it and you don't file your patent for more than a year, it's no longer novel, because you have a 1-year bar
Oh, interesting.
from when you can, but you have a 1-year bar that if you talk about it today, you have to file it by a year from today. Or it's not patentable because it's been known or used by someone in this country for more than a year.
Even if you're the one that knows it? No, wait, someone else knows it.
No, you know it and you start talking about it.
Okay. Oh, interesting. So it's proof that you know about it.
So that's why at Amgen, I'm sure what they did is someone's going to give a talk. You file the patent before they give the talk.
Oh, yeah, wait, yeah.
Exactly.
Multiple ones, yeah.
Exactly. And that's only in the US. Every other country, it's an absolute bar to novelty. You cannot use it, know about it, tell anyone about it before you file it, or in most other countries, you're not going to get a patent on it. So what you do is if you're going to file foreign, you file it, and then you talk about it. Then you offer it for sale. Then you give a paper on it. Then you publish the journal. But you file before you do that. So these are key things. Don't start talking about how great it is if you don't have a plan to file it. And don't start talking about how great it is if you don't have a plan to file it, especially if you're going to file in a foreign country.
You mean filed, not approved, so you can...
File the patent application.
Okay, yeah. So you start the process.
You start the process. Have a filing date. Have a little receipt from the patent office that said it's filed. Because it's key, because lots of people blow that.
How many times can you file the same thing in different versions of the same thing? If you're inventing it along the way and you're changing it, like how is there... I mean, is that totally subjective?
Yes and no. So there's a process when you first file it, and we're basically talking about utility applications here. Utility applications, because there are 3 different types of applications in the U.S. Plant design. A plant is obviously a new plant. A design is the Coca-Cola bottle. A design of a toner cartridge, the actual design of what it is. And then the utility patents, which are the methods, the process. So what we do, what I do with a lot of clients is, if they invent something that's really cool, they have a new drug that's coming out. Like I have a client that treats cancer, and they have a bunch of cancer vaccines. And so they file it, and then they realize, oh, there are changes to it, so it's probably enough to get a new patent. So they'll file a new application.
Well, the other one's pending still.
Correct.
Yeah.
And so what that will do is, for the stuff that's new, they get the date of the stuff that's new. For the stuff that's old, they get the date for the stuff that's old. So it's called a continuation in part, but they keep it pending.
Oh, interesting.
And you can do that up until... You can do that for as long as you have a patent pending. You have something still pending before the patent office you can hang off of.
Oh, and then you have all these separate patents hanging off each other?
Yes, you
Oh.
can. And then you can also do it, but each time you do that, a patent is 20 years from the date of filing. So if you file that original patent and it's pending for 5 years, and it issues, you have 15 years of protection. But if you file that original patent, it's pending for 5 years, and then you file another patent 4 years into it, its pendency time is now 16 years because you filed it 4 years in, and it's going from the first one. So if you keep adding to it and applying off that first date, you're going to lose years of protection.
And the protection only applies to that parts in the patent, so you'd have different parts that become unprotected? Is that kind of?
It kind of all relates to the earliest filing date. So you would have the first patent, so say the first patent was A, B, and C. And you're like, oh, A, B, and C is great, but this next one's maybe A, B, and C prime. So C prime would be new, so the filing date for A and B would be the first date, the filing date for A, B, and C prime would be the second date, and so you kind of have a bunch of different patents pending with different dates of when they issue, of different times of how long they're valid, how long the term is. But a lot of it's going to go back to that very first date, especially if they all have common subject matter. So every time you add on to it years down the line, you're taking years off of your protection.
Oh, interesting.
So it's really, you kind of have to plan how you're going to do it.
Right.
And the other thing is when you get a patent, you have to pay the filing fee, you have to pay the issue fee, and you have to pay maintenance fees. And those add up, especially if you have 10 patents on one product.
Yeah.
So you need to think it through, and these are questions about what's important, what's not important, how do we fund it, is this important, is this not important, do we keep it alive? And as the patent goes through, like the 3-year maintenance fee is a lot cheaper than the 11-year maintenance fee, by a factor of 5 sometimes.
And then do all those ones go to the same person who examined your first one, or is it kind of like a lotto system?
It's kind of a lotto system. I mean, it also depends, the initial examiner may have been promoted.
Even if they're still in the process at the same time?
Yeah.
Oh,
It may go to a different person who has a shorter queue.
okay.
The original examiner may have been promoted. The original examiner may have been in law school and graduated, so he decided to not work there anymore. It'll probably go to the same art unit, so you might have consistency, but it can go to any examiner that can handle that technology. You hope it goes to the same examiner sometimes, and sometimes if the examiner's a real
Yeah.
piece of work, you hope it goes to another one or they retire quickly.
That's cool.
So what goes in an application? In order to get, again, these are utility applications because plants are different. So there's a specification. The specification is the teaching tool. It's about 15, 20 pages about how you do it, why you do it, what you do it, to explain to someone. So, you know, if you're inventing a cancer drug, you want to be able to tell a fellow cancer researcher how you're doing it so they can make it. So it includes examples and components and what you put in and the ranges and the limits and maybe examples and test results to show that you have it, or you know, different things it can treat and how it can treat it. If it's a process, maybe the ranges, you're making a new drug, the ranges for how you do it, the temperatures, the equipment you need to do it. So it all goes in there to teach. It's a teaching document. Because again, it's that exchange for the monopoly, where you have to be able to teach someone how to do it, because as soon as the patent expires, it's public domain, which means they have to be able to use it. And then that's the make and use, contain figures. A lot of drug patents don't contain figures, maybe tables. A lot of, like, you know, a car would contain drawings and figures showing the various pieces, how they fit together. You have an abstract, which is a short summary, which is pretty much all the non-patent people, the judge, the jury are going to read, should it be in litigation. You have the claims, which we'll talk about in a second, and you have an oath of declaration, because the oath of declaration has to say, I invented it, I didn't steal it from anyone, this is my invention, you know, tell the truth, all that stuff. So the patent claims. This is your property deed. This defines what is yours. They are the most important part of the application. If I draft an application, suppose it takes me 40 hours, 20 of it are drafting the claims at least. They're a single sentence. They can be very long. They define exactly what you think the invention is. That's what you go back and forth to the examiner on about whether it's patentable. That's what they look at when you get in patent infringement. That's what the judge and the jury will look at. That's what you defend against. That's what you argue about. It's at the very end of the patent. And the purpose of the rest of the application is to show support. So if you have a claim and you don't have support in there, if you have something you're claiming to A, B, and C prime, and you know where in the patent disclosed C prime, how can you say you have support for it to get a claim on it? I mean, these are critical. You could spend hours just talking about patent claims. And for young patent attorneys, when they start with us, it probably takes 5 years for them to be any good at drafting claims, like really good at drafting claims. And then you're still learning because the courts keep changing the language about what works and what doesn't work. but you have to write about 500 patents before you get really good at it. And then you're still learning. I still change my claims every time I write them. And this is what defines what the invention is. This defines that you have a four-wheel vehicle and it's completely different from a three-wheel vehicle, and that's why you should get a patent on the four-wheel vehicle. And it really is an art form. Everyone has different ways of doing it. Lots of times you can tell, when I work with a number of patent lawyers, I can tell who wrote the patent based on how the claims read. Because we all have our own styles, depending on who you were trained, how old you are, what you did. So here's an example of a patent claim. It's a method of treating cancer through administration of an immune stimulant in combination with antioxidant. It's a really broad claim. Somehow we got it allowed because no one else had done it. So that's the broadest claim. That claim 1 is always the broadest claim. It's the independent claim. It's the broadest claim. And so anyone that treats cancer using an immune stimulant in combination with antioxidant would probably infringe that claim. Claim 2 is what they call a dependent claim. It says the method of claim 1 where the immune stimulant is a toll-like receptor agonist, which means you have claim 1, but you make it even more specific that the immune stimulant has to be a TLR. And the reason you have these varying claims is so, first of all, you have different breadths of them, so in case the first claim you write the examiner doesn't like, you have other claims you can pull in. Or if you're in litigation and your first claim gets knocked out and they don't infringe it, or it's invalid, you have things to back away. So you'll see kind of this myriad of claims in a patent application with different things covered. This one, I only put this one in, but you can have a method claim and you could also have a system claim. So it could be a method of treating cancer and you could also claim the system. It's more in just like, say, computer things where you have a method of doing something, then you have the computer system that implements it. And then 3 is also the method with the antioxidant is ascorbic acid. So you have different ways you can do that. Here's another one. This one's a little bit longer, and the reason this one's longer, this is a polishing formulation. The reason this one's longer is when he first wrote the claim, he did it himself. And he had maybe the first couple lines. And the examiner came back and said, I think you have something there, but your first claim is way too broad, you're never going to get it. So I said, okay, well, how about if we add in, the different etchants and maybe the high purity alpha? She said, you're close, but there's still art out there that shows that, and so you're not going to get that. So I said, okay. So then we added the ratios, and we added the polishing rate, and we added some of the other things. And when we got to that, it's a very narrow claim because you have to have all those, first of all, to get it allowed, and you have to have all those should you infringe. So if someone doesn't have has a polishing rate of 400, they may not infringe because it requires a polishing rate of 500. So it's this give and take of what you have and what you don't have. And it kind of depends on the technology. Like cancer is fairly new, treating it, so you have there's not as much out there, so you can get broader claims. Where polishing formulations are very old. So patent prosecution, it's not really prosecuting, you're not like arresting the patents, and it's called patent prosecution. And so what you do is you file it with the patent office, and you really are working with the patent examiner to get a claim. Supposedly you're on the same side. You file the patent application, it gets assigned to an examiner, they do a search, they see what else they know, they look at the stuff that you submitted, they examine it and they say, well, I don't think so, there's these references I found and you need to amend it. And so it's just this negotiation back and forth that can go on for years, or it can be very simple. It just depends on the examiner you get, the technology you have, how well it's written. So at the end of the day, you hope that you come out with a patent. But sometimes it can take multiple rounds with the examiner going back and forth. You think they're going to give on this, they don't, they give on this, they change this, and all. So, but that's why it's called patent prosecution. I don't know why they call it that, but.
That's the question before. What if you submitted like 3 versions of the exact same patent just to see which person proved it quicker? Would you, I don't know, maybe if you didn't tell them they didn't realize? I mean, like,
you could, but it's expensive.
It's expensive. I was thinking on corporate level,
We've done that. Sometimes you try to submit, suppose you have a method, a system, and suppose you have a car. That's an example. You have a car, and you have one directed to the car, and one directed to the engine, and one directed to the new electronics. Maybe you file one patent just for the basic car with everything in it, one for the new engine, one for electronics.
Instead of squishing them all into one.
Yeah,
Yeah.
because sometimes you do that because there's too much in there and it may go to different examiners, and so you can kind of play off of it. Plus you can also see which examiners are, when you file enough patents and you're in enough areas, you can see which examiners are lenient, you can see which ones have longer pendencies than others, you can see which ones are more likely to get stuff allowed than others, because the patent office stores lots of data that you can mine.
Oh, cool.
So there is a game you can play, and we've played it. Sometimes better than others. And the claims will change during prosecution. Those claims I showed you, they change a lot. But the basic teaching document won't, because you have to rely on that teaching document. It pretty much stays the same from the moment you wrote it, because that's what you're relying on for your support. So I know I'm throwing a lot at you, but it's a fairly complicated process, as many of you know. And then once allowed by the examiner, you pay the issue fee and it issues. So here's an issued patent. It's a vapor device, which this is one of our big clients that makes a lot of vapor devices, many of them filled with CBD. But it's a big industry and they do a lot. Just so you get a nice little ribbon copy, looks all nice and pretty. You can show it to your friends, hold it up at parties.
What are the fees roughly for the different pieces?
It depends on how large you are. Like if you're Amgen, you're paying the large entity, and so you're paying probably $1,500 to file it. Then you're paying $1,500 when issues, and you're paying maintenance fees of probably.
What is it actually based on though? Your income, like is it?
We can all be small entities.
Yeah, you're all small
Yeah, yeah.
entities. It's based on the number of employees you have. I believe it's under 150 or something like that. So small entity fees are about $785 to file it.
Okay. Isn't there like an independent person one that's like?
There's a
low income?
micro entity,
Yeah.
but you can only have 3 patents and you can only have so much income, and after you get your 3rd patent, whatever. But there's also the fees you have to pay to the lawyers to do it, which can be, it just takes a lot of time to do it, especially for really complex technology. Like certain things, design patents, plant patents, a little easier, but you're talking cancer, you're talking vaporizers, where there's just a lot of art out there to get something done. It's expensive. All right, so what does a patent give you? So there are a couple things to remember. A patent is a negative right. It's a right to exclude others. And I'll explain that in a minute, from making it. As I said, it's a sanctioned monopoly, and it's not a positive right. So let's go back to the 3-wheel, 4-wheel. So you have a patent on 3 wheels,
That's awesome.
and you're so happy. You come and you have a patent on 4 wheels. So you have at least 3, you have at least 4. Now, you may want to make your 4-wheel vehicle, but guess what? You can't. Because every 4-wheel vehicle has 3.
Oh, interesting. Yeah.
So you can't make your 4-wheel vehicle unless you get a license from him. Now, Steve can't make his 4-wheel vehicle unless he gets a license from you. So let me give you a real-world example of that. U.S. TVs. Back when they started making TVs, the U.S. had a huge, they knew what they were doing. They patented the crap out of it on the basic TV. Basic, here's a TV, Panasonic, all those. Pioneer was a pioneer invention. They got this area right here for the TV. Japanese came in and they said, this is a pretty cool invention. We can make money on this. What did they do? They got patents on all the improvements. The screen and screen, the remote control, the enhanced picture. So they started getting that. They got licenses from the US companies to make the basic TV, added all the little add-ons, because the US companies were like, yay, we're getting license fees. We're awesome. The Japanese are getting license fees from us. The Japanese started making these things and didn't give licenses back because they didn't have to.
Yeah.
So the US was kind of stuck in this area where they didn't have all the cool improvements. They didn't have the remote. They didn't have the screen and screen. And they were like, oh, that was really kind of dumb. So you have to remember it's a negative right. So while you have a nice patent on 3 wheels, if 4 wheels are really cool and she takes a license from you and doesn't give you one back, you're screwed. So you have to remember it's a negative right. It only gives you right to exclude others. It does not give you right to make it. And that's such a big thing for some clients because they say, I have this idea, I have this patent. Yeah, but there are a lot of other people that are doing the base technology underneath it, and you can't use it unless you figure that out or design around it. So it's not a positive right. It's only a negative right, which is really shocking to some people. So you have to remember that. Design and plan patents. I don't do a lot of them. We do a lot of design patents. It's basically just a lot of toner companies do that, where they take the basic design, like Brother does it that, where they take the basic design of the toner cartridge and you get that, or the basic design of the Coke bottle, or the basic design of something, and it just protects that basic design. That's it. You can it's really easy to make a different design and not infringe the patent. And then there are plant patents, and for some reason, which I don't know the answer to, they only protect non-tuber propagated plants, which means no potatoes. I don't know why they don't protect potatoes. Haven't really investigated it. So this is kind of the patent process in a nutshell. It's really complicated. You can get into a lot of trouble with it, but it's really cool when you start figuring out and how to use it. At least I think so. Foreign patent protection, again, US patents are only effective in the US, but you can prevent others from infringing products. I'll go into that in a second. There's treaties that allow you to file your application in many different countries, pay one fee, but then you have to go into the countries individually, and foreign filing is so expensive because you have to pay for the translations, especially the non-English speaking and the non-Romance speaking countries. It's really expensive. So the one cool thing about importing is I was working on a client in China, and they made compatible toner cartridges. And their Brother, they did it for Brother compatible cartridges, and there were probably like 9,500 patents on each toner cartridge, laser cartridge. And so we would try to find ways around it, and that was all well and good, but sometimes they got too close. And so Brother, or Epson, did a lot of it, would file an exclusion order with customs and stop their products at the port from coming in because they said they infringed. So that's another option you have. While you can't get protection in the other countries unless you file there, if you have something that's made in China that infringes and is imported in, you can stop it at the ports, which is pretty cool when you're... All right, patent infringement is unauthorized making, using for selling. So you using his 3-wheel to make your 4-wheel, very bad. You have to include all elements of the claim. So if you have a patent that says A, B, C, and D, and Tony here makes a patent that only says A, B, and C, he's not infringing because you don't have D.
Interesting.
And you have to have, it's called the all elements rule, and you have to have every element in order to infringe. You can only do it for issued patents, so your patent application you can't sue for infringement on. And the remedies, injunction, damages, and attorney's fees. And if you willfully infringe, if you say, screw Steve, I'm going to make my thing, I don't care, I know I infringe, that's willful infringement, you can get treble damages. Companies do not go out of business for damages in general, you know, like reasonable royalties, but they do go out of business and bankrupt for treble damages.
That's how that guy got in the Forbes 400 list. That doctor is telling that attorney mentor is treble.
Yeah.
Does that mean 3 times, or does that mean? Yeah.
At least, plus attorney fees.
Yeah.
Plus an injunction never to sell it.
That's why they tell the engineers to never look at patents.
Exactly. Exactly. Don't do that. All right. Next, we'll move to trade secrets. Trade secret is anything that has value from being secret. Competitive advantage, not generally known to the public. Coca-Cola formula, Colonel Sanders recipe, business lists, customer lists.
Customer list? You'd actually like file a patent for it?
Nope, it's not a patent. It's a trade secret.
Oh. Yeah. What do you do?
Well, I was going to get to that.
Oh, sorry.
So, trade secrets. What is a trade secret? Something that you maintain its secrecy, and because it's secret, it has value. It cannot be a patent because patents have to be disclosed. So so Coca-Cola has a trade secret on their formula. As soon as one of the key issues is it derives value from not being known, the protection only lasts as long as it's secret. So if someone were to find out the Coca-Cola formula, if someone were to figure it out and replicate it, it's no longer a trade secret because now the public knows it and there's no longer any protection. Now, if someone misappropriated, there'd be damages and things like that, and it could still be a trade secret if they contained it so that the public didn't know, but the function of a trade secret is you keep it secret. So things you don't want known by others, maybe your secret sauce, your customer lists, your business methods for how you retain customers, your top 20 prospects, your sales data. You know, if you're a private company, you know, so you want to keep those secret, and the trade secret has value by being secret. So it cannot be disclosed to maintain its value. As I said, it includes compositions, customer lists, recipes, anything that has value from not being known to the public. Anything you can use to your advantage by not being known to the public. I mean, legally, not known to the public. Does that make sense?
Yeah, I'm just trying to figure out like how you prove that you had it.
You keep records, you have processes to keep it secret, you have your employees sign non-disclosure agreements, you keep it under lock and key, you limit access to it.
So it's pretty much more enforceability. You're not proactively proving you have a trade secret to protect your secret.
But if you want to sue for damage, you have to show you took those actions to keep it secret.
Oh, okay.
You have to show that you weren't just throwing it out, that you were taking actions, reasonable efforts to keep it secret, and someone violated that. But if you're not keeping it secret, then you don't have protection.
There's just things that you consider in advance in case it comes down to that later.
Yeah, so there are certain things, like if you know that you don't want to patent it because you don't think it's patentable, or you think it can be easily designed around, so you keep it a secret, then you have to keep it under lock and key. You have to limit who has access to it. You have to have employees sign in. You have to not give it up. You have to,
If you're one person, what are the things you would prove that with? You know, kind of like independent level, small.
For you, maybe don't send it electronically. Don't, keep.
Oh, I know, like the
yeah.
operationally, but if you're trying to prove it later, like.
You would just your notes or the security measures you did, or you didn't give it access. Yeah, you would have a confidentiality agreement if you're going to show it to someone. You limit who you show it to. Maybe you wouldn't show them the whole thing.
What's the punishment, or what does trade secrets, how big of a weight is it in enforceability and stuff? Like, what do people do with, when is it useful? I guess is what I mean.
When is it useful?
Yeah, so I can see in Pepsi's case, I mean, that's like a good example. But like, do you see that often being an important strategy for like certain products or something? Or
Tony, do you have trade secrets in your business?
and what are they? No.
Do you have customer lists and things you want people to know how you do it?
Oh, okay, so that's to prove stuff like
Sorry,
that.
I'm calling you because you're reading your phone.
That's good examples actually. Yeah, I was thinking.
I'll give you an example.
Yeah.
SpaceX has 2 patents, and everything else is trade secret.
Really?
Yeah.
Oh, I didn't know that.
So
wow.
that's just their strategy, but they don't want, their deal is they don't want to patent it because they don't want the Chinese to find it out and then replicate it anyway, like
Yeah.
with impartiality, because their government will enforce the U.S. patents and won't grant the patents to SpaceX. So
Oh, interesting.
they, and that has to do with the fact also that a lot of it's regulated by arms trade regulations.
Right,
but-
yeah, I think too, it's in U.S.'s benefit. There's probably
Yeah, so, I mean, the way you control information like that internally is, at least for us, everything was marked proprietary and confidential,
Oh, yeah.
right? Every email that
Interesting, yeah.
included any technical information was marked proprietary and confidential. Everyone signed NDAs. No one got to see anything without signing an NDA, right? Like,
Yeah.
and all the servers were locked down. You couldn't just walk out of the building with stuff that was proprietary.
And they record access to certain data, certain
Yeah,
information, and you have to key in, and you have to do like lots of forms. But that's true. I mean, other countries don't necessarily protect technology, so if you don't want it known, if it's in a U.S. patent, it's public, and someone could use it in China and ship it over here,
Oh, so
or
we're seeing
wherever.
Different strategies,
But there are lots of things. Yes.
yeah.
Yes. What? Yes, dear.
So is there a difference between a strategy around a patent or protection from what you're communicating to the other people versus how you monetize it?
Like how you created it versus what you're going to do with it? Is it you?
Well, the difference is you can create something and you have to worry about how you communicate what you created. But the other thing is that communication strategy could also have how you monetize it.
So that's true. So Coca-Cola, they keep it a trade secret because it's really valuable as a trade secret. There are certain things that they know are going to be hard to contain the information, so you patent it because it's more likely to be public.
Oh, interesting.
Or you think about, lots of companies have intellectual property committees, and they decide, is this a standard that we want to protect because everyone's going to be doing it? Is this a product that's going to be really valuable and people are going to want to copy it and we can make more money in the marketplace because it's easily, they could easily figure out the trade secret. Certain things are easy to figure out, so you don't keep them as a trade secret, you patent them. Other things, maybe are harder to figure out, and it's going to be hard to get a patent because of what's out there or the international issues, so you keep it as a trade secret. Or there's certain things like, oh, I just don't know, is it an industry standard, are people going to adopt it, is it easily detectable? There are lots of things people weigh when they decide which way to go. Like how easy it is to detect. If it's really not that easy to detect that someone's doing it, you might want to keep it as a trade secret because it'd be hard to prove infringement because they can't detect that they're infringing.
Right.
If it's easy to detect, maybe get it as a patent because you can easily see it's detectable. You easily see they're infringing.
Yeah, as a point to like SpaceX, not that many people are building rocket ships.
No,
Yes.
not only that, but
Or Arnold's
no
report.
one else has access to their rockets to figure out if they're infringing with their internal components.
Oh, interesting. Yeah, yeah.
So if you reverse engineer a trade secret, can you market that?
If you reverse engineer a trade secret, it's yours. If you did not get it by illegal means,
Yeah.
Oh, yes. Yeah, it's like cool.
Yeah.
you can independently develop it. If you do not get it by legal means, then you can totally do that.
There's a lot of cases where someone will make a car with like a certain body shape,
Mm-hmm.
and then this might get into trademarking too, or design patents, but sometimes what'll happen is they'll make like the body shape of a car, and then someone else will want to make a spoiler that fits on that body shape or something like that. So a third party will go scan it with a laser scanner, and then sell the data of the surface scan
Oh, interesting.
like to that other company, so that then they can use that in their engineering purpose. And while it's a trade secret of the first guy what the actual surface data is, right?
Yeah.
Like he might not have patented the surface data because he doesn't want everyone to have it. But it's not illegal for the other guy to buy one and then just scan it and like grab that engineering
Oh, that's
data and hand
interesting.
it to somebody else.
Yeah.
You had a question?
No, the only thing I was gonna ask was being strategic on how you go to market with whatever you're inventing
Mm-hmm.
is as important, I believe, as the invention itself.
It
So,
is.
an example would be Tesla came up with its own battery technology, but decided to make some of it public because of a market revenue perspective.
Oh, because more people would buy into the early.
Yeah, so if they
Yeah.
share the technology, there's a reality of how they want to make revenue off of it.
Right.
So the overall question is, for you as an attorney in this situation, do you get involved in the economic strategy of how you go to market with whatever you're doing?
Well, when I did a lot of work for Toshiba in their printers and copiers, they were late to the game. Late. They were behind the 8 ball from Ricoh and Xerox. So we'd have patent committee meetings and we'd decide, well, what are our competitors doing? Well, they're doing that. Maybe we shouldn't do that. Is this something that we can use? You know, lots of times the licenses, the agreements were like 300 patents to 500 patents. Is this product maybe really key product that even a single patent is worth something such that we want to patent it and we don't want a trade secret? And so they would look at a lot of factors. What are their competitors doing? How does it fit in with the products they're making right now? Is it an add-on? Is it a long felt need? What's the revenue stream? How much is it going to cost to protect it versus keep it a secret? What are the benefits? Is it an industry standard such that everyone will adopt it? That we get some like kicker for, you know, being part of the standard and not protecting it, or we can make some money off of it. So there's so many things that they consider when they're deciding which way to go.
Yeah.
Depending on the size of the company, R&D budget they have.
Can you see patents that are pending, or are you able to only search for patents that have been approved?
You can see patents that are pending after 18 months from the filing date.
Okay, so no matter what's happening with them, 18 months you can look at anything pending?
If they don't file if they agree not to file them foreign, if you can file a not to publish request, but you have to meet certain things to keep it published, to keep it private until it issues. But after 18 months, you can see them.
Oh, interesting. Okay.
18 months from the original filing date.
Okay.
So if you file something, a continuation, you can see it. You file patent A and you file a continuation a year later, you can see the contents of the continuation 6 months later.
Oh, interesting. Okay.
Did that answer your question? Okay. Sorry, we're taking too much time. So we talked about the example. We talked about Coca-Cola, how they keep it secret. Executives can't be in the same room. They can't fly on the same plane. Same thing with the secret recipes. So what is a trademark? It's a source identifier, so you know who you're buying from. Gives you an idea of the brand, gives you an idea of the quality. One that's near and dear to my heart, at least Mark's heart, is protect what you have in mind, which is on our business cards. So trademark can cover goods, You can cover services. You can cover trade names. So the Apple phone, services, accounting services, legal services, software services, consulting services.
Are you trademarking your name for the services or the actual services?
The trademark protects the source identifier. So Nike means that you have, so it's Nike brand footwear, Nike brand clothes. So it identifies where they're coming from, so you know if you see something that says Nike on it, who made it. What can function as a trademark? Words, letters, K-Rock, numbers, 747, slogans, sounds, you got mail, colors, pretty much anything that serves as a trademark. Where you go, oh yeah, okay, I get that. Logos, YouTube, you know. Shapes, Coca-Cola bottle. It also functions as a design patent. It also functions as a copyright. You can have different types of protection for it.
Does some last longer than the other? Does the design,
Design lasts 14 years. A trademark you can keep renewing every 10 years. And a copyright lasts for hundreds of years. It can.
Yay, Mickey Mouse.
Yeah, yay, Mickey Mouse. Colors, the UPS colors. The pink for insulation.
You mean the stuff in the walls?
Yes.
Has its own trademark?
The color pink in the way for insulation.
Wow.
Yes, it does.
Tiffany box
Yeah.
Yep, it does.
and the Harley Davidson war.
Oh yeah, that makes sense.
Yeah, it does. Selecting the trademark. So what is trademarkable? It can't just be anything. It has to convey some sort of identity. It has to be somewhat arbitrary. You can't just say box for box.
Kleenex?
Kleenex is, that we get to that, Kleenex is generic.
And it's goofed.
Kleenex goofed. It's like saying you're going to make a Xerox.
Oh yeah.
So not all marks are equal. So you have fanciful marks like Exxon, Clorox, Google. You don't really know what they stand for. You have arbitrary marks, Apple, Yahoo, Fox. Suggestive marks, chicken of the sea. You kind of have an idea what they are. So it's a little bit harder to get them. It takes a while for them to be as strong. And then you have descriptive marks like Word, 99-cent stores, Original Mattress Factory. Those are harder to get protection on because you know exactly what the goods are. So you can't get a mark that's merely descriptive because then no one would be allowed to use that word for the actual item.
When you say strongest protection, is because that unless it's so unique, like
Yes.
do data, okay, and so like it's easy.
So there's kind of like this sliding scale of marks. So if they're completely arbitrary, fanciful, that you have no idea what the goods are from reading it, but chicken of the sea, it's more suggestive because you have an idea of what it is.
So you're talking about enforceability. The patent office doesn't care what you call it, right? Or-
Patent office, the trademark office does care what you call it.
Oh, they do. Okay.
They're not going to let you get a mark. They're not going to let you get Original Mattress Factory for all mattress stores because then no one else will be able to get it. You're going to have to
Oh.
show that it has meaning, that it has value, that you're the only ones that use it, that it has secondary meaning, that people are going to look at that and think of you, and you're not preventing others from using common words.
Interesting. Okay.
Generic, common descriptive name of goods or services identifies. It can happen when you use Kleenex. Kleenex made a sense. They didn't call it the Kleenex brand tissues. Xerox had a little bit of issue that says, I'm going to make a Xerox. No, you're going to make a Xerox. You're going to make a copy using a Xerox brand copy machine. So you really need to make sure that that doesn't happen because any value you may have in it is just gone. All your marketing money, gone. Poof, see ya. It's called genericide. It's a term, it's a disease. It's bad.
So if you trademark going to make a copy using a Xerox machine, in your ads, could you say, have somebody use a shorthand, say making Xerox, or would that undermine your trademark?
They're probably going to come after you for trademark infringement because you're not using it in a sense like. You have to be very careful when you use the names of others because you could be trading off their goodwill.
So you trademark making a copy with a Xerox machine.
They're never going to allow that to go
and then
through.
Your own.
Yeah, they're going to be like, sorry. They're going to say, no, people are going to think you're affiliated with Xerox. There's a likelihood of confusion, which I was going to talk about. So when you select a trademark, you need to make sure that it's available for use, which no one else is using something similar, you're going to get in trouble, and you apply for registration. You can apply for federal registration, state registration, and common law. Federal's the best because it protects the whole country. But
the question is the same office? Is it USPTO or is it a trademark?
Well, yeah, they
Oh, yeah, it is trademark. Okay.
yeah, patent and trademark office. Yeah, same office, different people looking at it. So you need to make sure that you can actually use it, that you're not going to have the mark infringe. So is it likely to cause confusion with a senior mark? And the senior mark would be you using the Xerox name for something similar. Or you...
Taking out one letter or something you would see on the
Yeah.
bags.
Exactly. So there are a couple factors, and I'm not going to go through all 9 because they're really long. So there's this, we're in the 9th Circuit, so anything, the 9th Circuit's pretty good about trademark. A lot of the cases are here. We're in the 9th Circuit. They have a list of factors that pretty much the whole country uses. Most of the federal courts, Supreme Court use to determine whether there's going to be an issue between 2 marks that you look at. And the trademark office looks at them all the time when you apply for registration, because they kind of do the same thing the patents do. What's out there? They do a search. Are there other marks that are going to be a problem? What are the goods? How related are the goods? And so just quick view of the factors are similarity of the marks. You know, using Xerox. I'm going to use a Xerox machine. Well, that's a problem because they're the same. Marketing channels. Are they going to be sold to the same type of goods? Your Xerox example, you're making copies. They're going to have the same consumers. So these kind of weigh in various things about distinctiveness of the mark. Is one Xerox and another Xerox with small? How distinctive are they? They're completely different. Why did you pick the mark? Did you pick the mark because you want to trade off their goodwill? You want people to think you're with them? How close are the goods? Copiers versus copiers. How strong is the mark? That's another one, likely expansion. So they look like Dairy Queen. They look and say, there's another Dairy Queen. Dairy Queen selling ice cream. This Dairy Queen selling, you know, chicken. Is it likely that a Dairy Queen would start selling other food products? Yes. Type of goods, degree, exercise of a consumer. So if you're selling billion-dollar, million-dollar hospital equipment under very similar names, the consumers are going to be very sophisticated that they're not, that's going to be a factor that doesn't count as much. Whereas if you're selling soups or canned goods or consumer goods under very similar names that are not very expensive, the consumers aren't going to put that time and effort to realize that the sources are different. It's kind of like this whole weighted thing of looking at it like you look at all the factors and decide, yeah, you know, would you be upset if someone used that name, if you had the first name? Would you be upset by it? That's what we tell our clients. They're like, but it's completely different. I'm not doing it. Would you be upset if someone used a similar name? Yes. No, maybe we should change it.
This is a question. You know, some companies spin off I'll use a drug example. Some companies will make the actual drug and they'll make the generic that is their competition. But they'll maybe sell it under a different name to get both revenue from the actual drug that they're overcharging people for and the generic that would be competing against them. It's actually them. But they'll like kind of do it under a second company. They'll almost like make like a different name to pretend that one drug, like one says Amgen, one says like you as a consumer would not realize your generic is from the exact same company. And I don't know if you see that. I mean, it's a big strategy, like larger corporations. I was wondering if the trademark office takes that into consideration. Or I was just wondering how you would trademark. Do you pretend you're 2 different companies, or is it?
It just depends who's going to own it and what they're going to do. I mean, it's kind of, yeah.
Okay.
Yeah.
Sorry, that's a weird question.
That's okay. And so other things to consider are copyrights, right of publicity. You can't use other people's names. You can't use your own name sometimes. You can't use surnames. And, you know, unfair competition and unjust enrichment. Are you trying to use what, you know, all the goodwill they built up for you? The other thing you want to do is, this guy searching, is you want to make, before you start using a mark, before you go to market, before you pick a mark, before you spend lots of money, search and see what's out there. Do a search of the patent office, do a search of the Google, whatever, see if someone's using it. And if you think there's someone using it, do it before you get so involved that you've bought advertising and marketing and bought product. Do it sooner rather than later. Protecting a trademark. You need to apply for federal trademark. It gives you constructive notice. You need to file as soon as possible because people are filing all the time, and the first person to file will often be the senior mark, and you have to show why you didn't file sooner, why you didn't do the things you needed to do. It's much simpler than patents.
It's a lot cheaper, right? Or theoretically?
Yes.
Okay.
If you do not register it, you can have common law rights. They're limited in scope. That's why sometimes you see mom and pop Dairy Queens that aren't the original Dairy Queen because they had common law rights, and so when Dairy Queen came in and got the national mark, they had their common law rights, they could continue to use them, and Dairy Queen couldn't do a thing about it. Same thing with some of the McDonald's. All right. You also have to use it. You cannot do it without using. You can file for it that you have an intent to use, but you actually have to use it to get protection. And you have to keep using it, because if you don't keep using it, you can't maintain it.
What was the Okay, like advertising? What's using it?
You have to use it for what you said. So if you're using it for drugs, you have to keep using it for drugs. If you're using it for Xerox for copy service, you have to keep using it for copy services. And you have to file renewals every 10 years. And when you file a renewal, you have to show that you've been using it over the last so many years to keep it enforced. You can't just hold on to it without using it.
Okay, and then can you expand on it for other things and add?
You can file new applications that expand on it.
Okay, and they're all separate almost then?
Yeah, they're separate applications. It depends how you do it, but you can file for additional goods and additional classes.
So could you revive a nostalgic brand that's been out of business for a long time and then go and
Maybe if they're out and they're not doing it and you can show that you're using it.
Oh,
Some people do.
Wow. Yeah.
So they have a duty to protect their mark, enforce their marks, and control the quality use. So you want to make sure if you're McDonald's that, that if you have franchise McDonald's that they're actually selling the product that you want McDonald's to sell, otherwise it weakens the brand. So that's a big thing why you see them enforcing it, because if they don't enforce it, if they don't have the quality controls, they can lose all their rights in the trademark. All right, so remedies, again, infringement, injunction, money. And now, last one is, what is a copyright? It again is in the Constitution. This one is about useful arts, authors, and writings. It protects the expression of the idea. How you write it, how you say it. That's why there's so many books, there's so many movies about Boy Meets Girl, you know, they fall in love, whatever, but it's the expression of the idea. It's not like a patent where it's the actual idea, it's the expression of the idea. It's the how you write it, how you do it, how you program it, how you present the material. Copyrights cover TV shows, music, books, software. They don't cover ideas, raw data, concepts, like patents cover concepts. They don't cover historical facts, procedures, processes. Those are more for patents. Systems, they don't cover principles again. So it's just the expression of the idea.
It's like the actual literal.
It's the actual code. It's the actual TV show. It's the actual screenplay.
So how much could someone plagiarize, like say a book, like how? Or that's a hard to answer, I guess. But is that kind of?
You have to look at, well, they can be independently developed. You have to look at how similar they are and if the person had access to it.
Okay, and probably what's used for. It's kind of like the other things too, like, yeah.
Yeah, copyright's a little tricky because you have to see how, like if you and I write the same book, but we do it independent of each other and we don't have access, then we can both do that.
Oh.
But if I write the book and you have access to it and you take a lot from it, then no.
Oh, wow.
Yeah. So initial owner is owned by the author. It's the person that makes it. It's the wedding photographer. It's not the person that hires them. You get your wedding pictures. You do not own the pictures. You do not own the negatives. The person that takes them owns it. You get a copy. You buy a book. You do not own the book. You own the copy of the book, but you cannot copy it. You cannot make a novel, and you can't make copies to sell to others. You can sell that book, but you own the copy. With your wedding pictures, you own the copy. You don't own the negatives. So it's a real distinction. And lots of times they're owned by the employer because it's a work for hire. If it's made as part of your employment, it's a work for hire, so your employer owns it. Provided. Copy owner has the right to copy it, produce it, display it, publicly perform it, write a book based on the book, write a movie based on the book, publicly show it, offer screenings, all of that. But it lasts for a long time. It lasts for 70 years or 120 years, and after it ends, it's in the public domain, like the Mona Lisa.
So that's assuming it's inherited to somebody, right? So what if someone dies and they have no heirs, or?
It can, but it's kind of based to the author, so it just depends on how old it is and when if they did what it's. Yeah.
And probably just who your competition is that's gonna try to use it. Yeah.
Right. All right. And copying is not theft. It's not always theft. Sometimes it's true. There are limitations. You can use it for fair use. If you put it in an ad, if you use it for a limited time, if you use it for educational. Parody and for sale. So fair use is quoting lines for a song in a music review, quoting a medical article, copying paragraphs for use by a teacher. So there are certain times you can do it and you're allowed to do it. You're not making profit from it. You're looking at the use from it. You're not trying to gain. You have to look at the purpose of it. Is it nonprofit? What type of work is it? How much have you used? If you just use a couple bits of a song in a review, if you just do a couple bits of a movie in a review, if you're using it as an educational purpose, colleges using it to do teaching, you can do that without having to pay the owner or be liable for infringement. Parody is another one. You can make fun of it, like this one here. So yeah, they did it, but no one's going to think they're the same, and it's a parody. Or the cat is not in the hat. Again, it's parody. And the other one is the first sale. So if I buy a book and then I sell it to you, that's okay, because I didn't make any additional money other than the money that was laid out. But I can't make copies of the book and sell it. But I can sell my copy to someone.
What about quotes?
Quotes aren't protectable.
Oh, because they you'd have to register or you'd have to copyright your quote, right?
I mean, because they can. I mean, sometimes they are, but.
Just take a quote out of a movie and they put it in a game.
Paris Hilton did that. What was her stupid?
But it's not. But it's not like the whole. It's a very limited portion. You have to look at the proportion they took out.
Didn't she get like "That's Hot"? Wasn't that stupid thing? I don't know. I just probably didn't pay attention to her little.
And there's hardly any artistic value to one, Paris Hilton, or two, that small limited quote.
In terms of the parody rule, if what?
No,
You're
you're
yeah.
parody, yeah.
Oh, yeah. Well, yeah, I have a specific question because if you're
Sorry, I just screwed
oh
you.
no.
Fix it, don't worry.
If you're making a parody of something, maybe using someone's art, and the public confuses the parody with the artist, the original artist that created this art, could that be an infringement?
It could be. It depends on how close you are and what you're using it for, and yeah.
Parody, does it have to be in a comedic form? I mean, like, or
I mean,
what's the, yeah.
I mean, it's kind of like what he said. You know it when you see it.
Yeah, yeah.
There aren't any hard and fast rules necessarily, but you look at it and you're like, oh.
Right, it's possibility. It's about the person that's going to try to enforce
Yeah.
it for it.
It's a copyright infringement as you're using it without the copy owner's consent and no exception it gives. I mean, if you use a whole work and you say, oh, no, it's parody. Well, no. But a small quote taken out of something, no. Remedies, again, civil remedies, damages. You can also have criminal penalties because you always see that thing when you start a movie that copying is against the law and you can go to jail and you can, don't do it, it's bad. Talked about some can work together. Patents and trademarks can work together because you're kind of protecting the same thing. And others can't. Trade secrets and patents, because they're opposed to each other. When you keep secret, when you make public. And then just the last thing is you can license all of it. You can license it to others. There are lots of reasons why you might license. You have a patent. I'm sure you see it lots of times. You have a patent, you license it. That's how you recoup some of your investment back. So it's a contractual relationship, gives a permission to write, to use it, and you pay money to the other side. They can be any type. They can be all kinds. Commercially exploit it, mutual benefit, offensive or defensive. You want it to prevent your competitors, so you get in bed with one of your enemies. What can be licensed? Patents, trade secrets, anything. You can also license non-technical from your trade secrets, business methods, customer lists, training materials. You see that a lot. It doesn't necessarily have to be one of the four in order to license it. If you can get value from it and someone will pay you, you might as well license it. They can be exclusive, non-exclusive. You can give it to one person, you can give it to many people. You can limit it to this certain use. You can only use it in this area. You can only use it for cancer drugs. You can only use it for these types of cars. You can limit it to manufacturing. You can only make it for me. You can limit it to distribution. I'll make it, you distribute it. It can be a joint venture where you both contribute and you both jointly own some of it. It can be sponsored research where you pay another company to do the research and you end up owning what they come out with. I mean, there are just any million forms you can do. Why? You get income, you recoup some of your R&D. You can get in new markets. You can have, like, Cisco lots of times did licenses to get new markets where they didn't invent it. They didn't pay the R&D costs, but they wanted to use it in their products. You can test it. You can increase your market. Cisco did that sometimes where they could get into new markets, get products from small little companies that they could try out without having to enforce them, worry about them, pay for their employees, all the hassles. Defensive, you can require cross-license. There's a bug on there. Like Toshiba would try to cross-license to limit the amount they'd have to pay. Settle litigation, that's a big one, where you enter a license to not get into litigation. That's what the patent trolls do. And you can reduce the royalties you may have to pay. So you try to like make it work. So there are defensive reasons to do it too. Disadvantages, you may lose sales, you have to pay, you may lose your control, especially if you give the exclusive license. Sometimes you're not able to do what you want to. If you give your license to someone else, now you have competition. You may assist your competitors by giving, someone you don't trust that's not going to treat it well or do what they need to do. And you have to watch over it and keep track of it. And license fees, you can do it any way you want. You can pay any way you want. You pay the licensor for the grant, you can pay them in a lump sum, you can pay them royalties, you can pay them annual fees, you can pay them nothing, you can exchange things. So basically, any way you want to structure it that works for the two parties and is not a monopoly or antitrust works. And finally, this is a summary at the end of everything we talked about. It should be in the PowerPoints, just what it protects, how it protects it, so it'll answer a lot of your questions.
On license too, so you're licensing certain things and you already made a contract with each other that you have these terms, I'm giving you this for this. If they break a term in the contract, does that make the entire thing invalid?
It depends. It depends on what you can say. If one thing is invalid, the other one's not. If it is invalid, it depends on what it is. If it's supposed to be kept confidential and they breach that, well then you don't want to continue. But if they just miss a payment by 3 days, then do you want to invalidate the whole thing? You can, you can structure it any way you want to.
That's interesting, yeah.
It's an art.
Because I think I have seen a disclaimer in some contracts where, like, if there's certain amount of payments, certain things are null and void, just as like a protection, I think. Maybe. Yeah, that's interesting. How often do people come in maybe trying to get like one type of, they come in, I want a patent for this, and how often maybe are there opportunities to leverage the other ones that are maybe less known or less used that, I don't know, there's some easy examples that people miss, because like even looking at design, I don't know really that many people doing design patents or designing cool things, but like, I guess it all goes down to the strategy, so it's not an easy answer, but.
No, it depends on what they want to do, what their goal is, what is their end game, do they want to make money, do they want to make value, do they want to get out at the end of the day, do they want to stifle competition?
And how long is the design patent valid? Is it like
14 years.
14 years, which is less than the patent. Yeah. Do you ever see them over? I know that Mickey Mouse example is like the most famous example, right?
For copyrights?
Yeah. And I don't know if I know that whole thing, but are there other times like are there examples you can think of that one thing has like a design, a patent, a trademark, and like almost like a little bit of everything? Where it's like
some people some people have a design patent on, like, you have a toner cartridge, you can get a design patent on the toner cartridge, you can get utility patent on the toner cartridge, you can protect the name, you can get copyright protection on maybe some of the user manuals and things like that. Software is the same thing.
Could you make a design patent to exclude people from making a sub-cartridge that fit in your device? Like, you pretty much exclude your competition by making a design patent on the original device, such that, like, if it was a printer, I want to design patent it so that...
That would be more of a utility patent because
yeah.
it's the actual design of it, not how it necessarily goes in or functions.
Okay. Yeah.
Right, but I've seen electrical connectors where they'll just, design of a connector and nothing else will plug into that device.
I just said...
And you can't design around that.
Right, that's hard.
Yeah, I saw in medical devices when they would make two things that were components that fit together. Say, for example, a device. The easiest example would be like something to smoke out of and the cartridge that goes into it. They would design the device in such a way, and the cartridge in such a way that like a notch or something little between the two would be patented, such that it would exclude people from creating something that would fit. And it was just all because they knew, like, if we create the device to use it, we want to create the only thing that can be used in this device and not let all our competitors use our expensive device with their cheaper cartridge.
Right, no, they can do that. Yeah, I mean, they can do that.
Yeah, and that wasn't a design either.
I mean, you can get lots of things.
Yeah, it's like, so when I'm asking questions, they're really hard questions because it's so dependent on what it is.
There's an interesting case where there's new legislation, well, not new. In 2000, they did the Digital Millennium Copyright Act, and I don't know if that was actually in 2000 or not, but like it was around 2000. And it basically didn't let you attempt to like reverse engineer like certain like rights management stuff. And so Blu-ray players would only play back like official Blu-ray discs.
Oh yeah, they
Right.
got the thing into the, yeah.
And then someone went and broke the encryption key and then published it, but the company sued the people that published it because it was protected under DMCA. And so it was sort of like, it wasn't a patent and it wasn't really a copyright. I don't think that actually covered it, but it was like violation of that specific law that like, so instead of getting a patent or like trying to use copyright to enforce the specific encryption key, they like lobbied Congress and got a law written
Oh, wow.
that would prevent you specifically from defeating that like way of copying or like interfacing with their stuff.
Right, so it was good to have an old DVD player. You could still play all the.
Well, so a lot of that's used in modern day, like like John Deere doesn't let anyone who's not a dealer work on the electronics in their tractors.
So they
You're
charge
not
you
allowed to
dollars.
reverse engineer it because of DMCA. So now there's people trying to lobby Congress for right to repair, which is like a whole. And so
Oh.
basically, it's like kind of a weird like side channel copyright that the lobbyists from like MPAA and RIA and all those guys went and like added this new law that sort of did that to keep people from being able to get access to the tools that would allow them to reverse engineer
That's so
that
interesting.
stuff. Yeah, it's super weird, but
Yeah, I've seen that with cars too. Yeah, and it's like almost like the whole strategy is like it's gonna be more expensive to do the maintenance, but if they're the only ones that can do it, they kind of create almost like a market segment of just
Well, Tesla's trying to keep other people from repairing their cars.
yeah.
But Massachusetts, I think,
I do
won't
remember
allow
that.
them to do that.
Yeah, because yeah, and then
You have a right to repair your car.
yeah.
So you have to be able to buy Tesla parts.
It's really interesting. All these things. There's so many different ways to leverage them.
yeah, but the patents that go on forever. So 3D printers weren't cool until like maybe 10 years ago. They started becoming like hobby available.
Right.
And that's because Stratus has sat on the patents from like the 1980s on. And it wasn't even, their main patents had expired for like 10 years by the time MakerBot went and made theirs, but they had patented each little thing like 5 years after every time. So when they captured the core research in the very early days, then no one else was really messing with it because they owned the whole market and they were selling them all for like $3 or $5 million to aerospace companies. And so even though the stuff was actually way cheap to make, their patents artificially like inflated its value because they captured the whole market in that monopoly. And then no one could actually create a 3D printer because the further on patents that they filed lasted a long, long time.
Right.
And you couldn't get enough of the components together to actually build one
On your
cheaply. Yeah, on your own.
So
Yeah.
Without violating.
Is it correct that for personal use, not for profit, you can, pick up a patent and build it and use it for yourself? No, that's not true.
That is not true at all.
I was always under the illusion that that was true.
Nope.
So,
No, sorry, Ray.
so you can't, even though it's just for your own personal use.
Says anyone who makes, use, offers for sale. Nope.
I'm sorry.
You hope you don't get caught.
Um,
I mean, there's probably not any damages, but no.
right, there's no doubt, yeah. Well, you did
What if it was
apply
fair
one of
use
them.
and you were doing it to learn how to make something?
Nope, 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 nope. Mm-mm. What?
So, when looking at everything that you invent, there's different stages at which you want to protect what you've done.
Mm-hmm.
At what point do you have to kind of consider kind of the economics of it? So, for example, you can get a lot of documents online and fill them out yourself, and some of that may work in certain situations. What's your thought process for young designers who can't afford to do a lot of this work? Is there anything that they can do within the first years of their invention that can help prepare them for the work that you do?
For doing it proactively and not planning it into their strategy, yeah.
I mean, there are a couple things you need to do. You can file a provisional patent, which gives you protection for a year before you file the real patent.
How much can you include that? Like, how much do you have to know, or is there?
The more you have, the better. But basically, lots of times we do it. It's just a brain dump, And so that's an inexpensive way to do it, but you're relying on what you put in there for your original patent, but that only gives you a year. Because when you start talking about it or doing things, the clock is ticking for you to get protection. Protecting your trademarks is much simpler. It's a lot less expensive. Copyrights are very inexpensive. So if it's code and things like that, you might want to protect your code by copyright.
Yeah, I was wondering about that. When does it when is it software and when is it copyright of, I don't know. So software patents and things like that.
Because the software patents are going to protect how it works, the process, where the copyright is going to protect the code and how it's written, the expression of it.
What if you copyrighted every single possible expression of code to do a certain thing? Does that make sense?
No,
I mean, I don't know, you could, I mean, it's different,
Yeah.
just write code.
I mean, because then you get into, that does get expensive too, because it's $50, I think.
Yeah, and then they might look at it too, but it's not a,
Right.
yeah.
So is the answer to your question then, for a young designer or young inventor, it's never too early to begin thinking about.
Correct. Because you can lose rights if you don't. And unfortunately, it's an expensive process, so maybe you want to go to partner with someone, go to some of the, see if you can get a grant, some of the universities, some of the think tanks, you guys, things like that can help out.
Is only patent able to be used for collateral or these other things, or is that what we called it for earlier?
Yeah, you can use them for collateral. I mean, trademarks can be copyrights, patents generally.
Like how do there's people that do there's people that specially do the valuation of those, like how do you?
There are people that do it, but that's also expensive. But lots of times, like companies who use it for, large companies who use their patent portfolio as collateral for, like security, it's collateral for getting new loans and things like that. It's harder for like the one-offs where you have one or two or a trademark or a copyright. It's much easier when you have like a whole line of them. And so they use it for security interest for bank loans and things like that.
Could a startup do that with like proof from like a what are those self-funding campaigns?
Kickstarter?
Yeah, Kickstarter. Like, could they use kind of? Because I mean, that's almost like proof of the interest in the idea. Could you pair those two together as a startup and be like, here's this idea I have. Here's how much like just the valuation is. Like how much I've already got, and then kind of project from that and use that as like a collateral. That's a really complicated question.
Yeah, that's a really complicated question.
sorry.
Yeah, that's like that's I don't know.
I never even
Because
thought
you
it
don't
could be
really have the
collateral.
IP right. Then you have an idea and someone thinks it's valuable, but
Yeah, because that's actually
that'd be hard to take to a bank.
Yeah, they're gonna take a bank. That's like probably the most proof you could have. Like all these strangers online. That's their actual money.
Yeah, that's not. Yeah.
There's
Oh, it's not?
there's absolutely no value to that.
Oh, so you can't like project that out and be like, here's what the market wants.
No, that's just people
Okay.
being kind.
Yeah.
Yeah.
Sorry.
What? Huh? What'd you say?
Everybody likes to look at value.
Yeah, and it's like the
Okay.
intangible things are hard to.
The biggest thing about value is what somebody will pay you for it.
Yeah.
So a lot of people will give you a document that says it's worth this,
Right.
but if the bank will lend you the money on it and nobody will pay you for it, it has no value.
Interesting. And then are you invalidating it by getting more rejection letter from the bank? Or are you like devaluing?
That has nothing to do with the
Okay.
value.
It
Yeah.
is all noise.
Oh, okay.
You can go sit down in the coffee house and say my idea is worth $1 million, but
Right.
if no one gives you $1 million, it's worth absolutely what somebody will give you.
Yeah, interesting. That's why I was asking like who does the valuation, like
But those are for like people that are buying companies and things like that, where they have like
right,
large
they do-
portfolios that do evaluation.
due diligence. They're doing like a
Yeah.
lot of data gathering.
If you're starting a small business and you're a brand new engineer designer, you have $15,000 in the bank, and you go start a company, and you patent your idea for $12,000, and you only have $2,000 to mount a legal defense. If someone
Yeah.
else infringes, you're screwed.
Yeah.
So you have to consider that you actually will mount a defense of the patent, like when you file the patent. You have to, if you're going to use it in that way, unless you're licensing it or something like that, right? But because generally you can use patents offensively or
What
defensively,
time is
right?
Michael's flight?
Like, you have to figure out beforehand if you're going to have the resources to go after
Yeah,
other
exactly.
people that
Yeah,
are
so what time
infringing.
is Michael's flight?
Yeah.
So for big companies, like if Microsoft goes and starts using some little guy's patent, he's going to try and sue him for sure, because
Oh.
there's a lot of money to be had. But if I infringe on someone's patent and I have like 10 brands to my name, why would they sue me if they're like Toshiba or something?
I have a question about the recent changes. That totally reminds me of it. Is it now more easy to invalidate prior patents because of the AIA, or is that an issue? Like, when do they re-question a patent? You were been granted, you get, it's yours.
There's some process you can do, but they're very expensive.
Very expensive, but does it so I thought it was happening more often now.
About the same.
Prior art's over though, right?
Huh?
They don't do prior art anymore. It's all first to file now, right?
Oh no, they still look at prior art.
Really? Okay.
Oh, absolutely. That's how they.
Oh, as
yeah.
whether or not you can get a patent, but you can't go back and get a patent before someone else who filed before you. You can only invalidate theirs, right? I thought that changed like in the last.
It's tricky.
Oh, okay.
Yeah, that's a tricky one.
Okay.
And I apologize, but I do have to go pick up my
no problem,
nephew
yeah.
at some point
Okay.
because he's coming at 9:30.
Oh, no problem. No.
Yeah, I'm sorry. My nephew's flying in from Cleveland. No, he's flying in from New York. He used to live in Cleveland, and he made the reservations before I had this obligation.
problem.
I am so sorry.
Yeah, no, this is great. Thank you.
Hey, no worries.
Yeah, I appreciate it. We have the audio on, or we will have the audio.
Oh
on.
yeah. Let me end the recording.
And then we